Hello, everyone. Thank you for joining us for this special webcast on legal remedies available in the COVID-19 economy, specifically for Japanese companies doing business in ASEAN countries. This webcast is brought to you by the Singapore International Arbitration Center, or SIAC, and the ASEAN Japan Center. My name is Michelle Sonin, and I am the head Northeast Asia at the Singapore International Arbitration Center. I'll be your host and moderator for this panel discussion. COVID-19 has upended the global economy as entire industries have been forced to weather lockdowns and significantly reduced demand for trade and services. For Japanese companies doing business in ASEAN, particularly in the manufacturing sector, disruptions to supply chains have resulted in many businesses being unable to fulfill contractual obligations or incurring losses due to their counterparties' inability to perform. In today's webcast, we will explore the legal avenues available to Japanese companies doing business in ASEAN that have been affected by COVID-19. I am delighted to welcome a panel of leading experts in cross-border trade, investment, and dispute resolution in Japan and ASEAN to share their expertise and insights with us today. Joining us are Mr. Chan Leung-sun, Deputy Chairman of the SIAC Board of Directors and Senior Counsel and Arbitrator at Essex Court Chambers Duxton. Mr. Chan is based in Singapore. Mr. Min Dang, member of the SIAC Court of Arbitration and Senior Partner at the YKVN Law Firm. Min is based in both Singapore and Vietnam. Mr. Hiroyuki Tezuka, member of the SIAC Court of Arbitration and partner at Nishimura and Asahi in Tokyo. Mr. Peter Kony, counsel and head of dispute resolution and investigations at the Tokyo office of Clifford Chance. And finally, Ms. Fu Yuet Min, director at the Drew and Napier Law Firm in Singapore. Thank you all for joining us today. I very much look forward to our discussion. I'd like to start by looking first at the kinds of disputes we can expect to see arising out of COVID-19, specifically disputes involving Japanese parties doing business in ASEAN countries. Peter, can I turn to you to share your views on this topic?
Sure, thank you, Michelle, and thanks to SIAC and the ASEAN Japan Centre. Yes, the question is, what type of commercial disputes have been arising in the ASEAN region for Japanese companies doing business, particularly manufacturing companies? Well, as we know, the practical impact of COVID's been very widespread. It's caused massive disruption to business travel. That's led to a lot of cancelled business meetings, cancelled closings on deals. There's been government lockdowns, as we know, that have been, in some instances, far-reaching, reduced manufacturing hours for plants, businesses closing early, etc. And even recently, we've seen some countries taking direct actions against other countries in terms of trade, the dispute between, for example, the PRC and Australia in relation to trade and tariffs. So there has, as Michelle said, been a very wide-ranging impact. Now, in short, for Japanese companies doing business, generally this has led to a general slowdown and delays in trade and investment. And what this can often mean is, of course, disputes. Now, what I will just give you a couple of factual scenarios of disputes that I've seen in my practice with my colleagues, but this is just a glimpse. My colleagues on this seminar have their own experiences and stories as well. One typical one we see with Japanese purchasers and sellers is claims by foreign counterparties in different ASEAN countries to either suspend or terminate performance of their duties under a contract on the basis of COVID-19. And it's usually for excuses such as the pandemic has caused the contract to become too expensive, or the delays have been too significant that they can't perform in accordance with the terms. One particular example, which we've seen now about 2 or 3 occasions, is where a foreign supplier who has goods stored at a port has incurred extra costs because the pandemic has caused the port staff to work reduced hours, meaning that they're shipping off cargo at a reduced rate. Therefore, the supplier is incurring extra costs to maintain those goods on the port prior to shipping them out. Now, in one case, the contract didn't provide for any price escalation because of the supplier's additional incurred costs. But nonetheless, the supplier asked the Japanese buyer, can you please increase the amount you're paying us because we've incurred extra costs at our end. And in this case, our client was refusing to pay extra and was demanding delivery. And then the supplier was saying, well, if you're not going to agree to that, we're going to call a force majeure event, or they were talking also about frustration. So that's a typical type of dispute you see in supply contracts. Now, what force majeure is, what frustration is, material adverse clauses, my colleagues, Tezuka Sensei, Yuet and others will talk to you about that shortly. Another typical scenario we see is on large energy or infrastructure projects where Japanese companies have a role, either as an employer or as a main contractor. And again, it involves delay. For example, Japanese contractors may have supply agreements for materials out of China, and particularly at the start of the pandemic, delays in providing materials led to delays in the Japanese main contractor performing its scope of work, which led to claims or potential claims of liquidated damages from the employer in the project. Again, the main cause here is delay. Now, in terms of these projects, how we've seen Japanese companies deal with them, as with other countries, they naturally enter into a negotiation and try and settle the matter amicably. But what we're starting to see now, and what we expect will happen over the next 2 to 3 years, is that some of these settlements about delay and also additional costs that are reached in the middle of projects prior to their completion, they will probably form the seed of disputes after the project is completed. Why is this? Well, we commonly see settlement agreements reached mid-project are often badly drafted, often by the business side, no legal team input, which means that there's a dispute about the terms of the settlement at the completion of the project. So the moral of the story there is, of course, try and ensure that any settlement is properly documented and covers all the scope of what it's intended to cover. Just moving on to my second point, which is about timeline for disputes. As I mentioned earlier, the big word is delay, and there is, of course, a delay not only being used as an excuse for either suspending or terminating contracts, but also in resolving them. My colleagues will talk to you about the impact of COVID-19 on formal processes such as arbitration and court proceedings shortly. But we also see, frankly, in the usual commercial dispute, the usual commercial negotiations, long delays in the matters getting resolved. And I think that's just naturally a consequence of the overall slowdown that we're seeing across the board. I think that's all I wanted to say at this moment. Thank you, Michelle.
Thanks very much, Peter. That's really interesting. It sounds like delay is really the name of the game right now, and we're going to be looking at different ways in which we sort of handle the consequences that come out of things like delay or suppliers not being able to meet those kinds of obligations or increased costs as well. May I see if perhaps Yuet Min has some additional comments to add there in types of the types of disputes you're seeing, particularly in Singapore?
Just to add a few short points. I think in Singapore, the government has come up with a system for assessment, for brief assessments, which hopefully take less than 6 months. And I understand from my colleagues that they usually take 2 to 3 months to resolve. And these involve mainly disputes relating to landlord-tenant kind of disputes, event and tourism related kind of disputes, especially with all the cancellations of events that are going on, weddings and things like that. Construction contracts, supply contracts, those are quite common, especially in this kind of climate. And performance bond issues are also one of the main areas of contention. One particular dispute that I've seen relates to supply and orders of test kits, especially at the beginning of the pandemic. So there were certain orders made for urgent supply of test kits. And these particular test kits were originally approved by the government, but later on the governmental approval was withdrawn for that particular kind of test kits, and the order had to be cancelled, and there was a dispute. Thankfully, the parties were quite reasonable in that case, and they managed to resolve the issue. The cancellation was accepted with certain kind of compensation. And that went away quite peacefully, thankfully for my client. So these are the kind of disputes I think we see, in addition to, of course, what Peter has mentioned earlier about delays. I mean, I think that is common, a complaint that we will hear for some time to come.
Thanks. That's a good insight. I noticed that you kind of alluded to settlement as well, and Peter did as well. Are you both seeing more settlement in light of COVID-19? More parties trying to resolve it amicably rather than go to dispute resolution procedures?
If I may comment very quickly, Michelle, the answer is yes. We see across the board commercial parties being perhaps more reasonable and more flexible than they were prior to the pandemic, because I think there's a general acceptance that this is an unprecedented environment that we're in. And parties do seem across the board to be a bit more willing to talk turkey and to reach settlements, but it's not always the case. But we'll see how that pans out over the coming months and years, probably.
Thanks a lot, Peter, and Whitman as well for those comments. Let's turn now to talk specifically about the legal theories under which parties could attempt to seek recovery. And we'll look first at Japanese law. And if I could ask Hiroyuki to come in and tell us what kinds of legal remedies are available under Japanese law, and a little bit as well about the different approaches taken in other Asian countries. Hiroyuki, please.
Thank you, Michelle. Can I share my slides? So when you talk about force majeure, under Japanese law, if there is a force majeure clause, then the issue as to whether default in question triggers that clause is essentially a question of contract interpretation. So it may depend upon whether the relevant force majeure clause refers to pandemic, epidemic, declaration of a state of emergency, lockdown. The consequence may be different, but more importantly, particularly for the understanding by the Japanese corporations, the approach taken when interpreting the contract or the interpreting the force majeure clause may be different depending upon the jurisdiction. So it is not difficult to find a literature which broadly states that there is no principle of force majeure under common law, unlike some civil law jurisdiction. The point is that under common law, they argue that unless there is force majeure clause which can apply to the circumstances, there is no force majeure defense. And it also goes further to say that under English law, for example, the approach in interpreting such force majeure clause may be stricter than you expect under Japanese law. For example, even if when there is a catch-all clause which follows the list of specific force majeure events and such other events beyond the parties' reasonable control, then it may not be interpreted broadly, and it may be interpreted only to include such event which is similar to what is specifically referred to in the relevant force majeure clause. So this is a kind of a pitfall for Japanese corporations. And talking about the Japanese law, the Japanese civil code defines the legal remedies for the contractual default. And interestingly, it has been interpreted that if the default is due to grounds not attributable to the obligor, then the obligor would be exempted from damages claims and termination of contract. And this legal principle applied by the Japanese courts are now in the new civil code. The part related to the laws of obligations of which have been amended very recently. So contract entered into after 1st of April this year is subject to the new civil code. But basically the rule is the same, except that under the new code, the obligee may terminate the contract regardless of the existence of the grounds not attributable to the obligor. And I would say that non-attributable grounds applied here may be broader than what you understand the force majeure is. And another interesting thing is that under Japanese law, monetary claims are not subject to force majeure defense at all. And I refer to the Subcontract Act, which is a little bit trickier aspect of Japanese law, where the protection of subcontractors, which is very broadly defined, is set forth in the Subcontractors Act. And in addition to the subcontractor as defined in the Act, in response to the difficulties faced by the mid and small class sized corporations, METI has issued some requests to various business associations to consider the difficulties, and they encourage discussions where the subcontractors or the suppliers have difficulties in timely making the delivery or facing the additional costs. So they even say that, you should consider no claim for the delay, or you should consider paying additional costs, which is required for the subcontractors, etc., to meet the deadline. Okay, please turn on to the next page. So this just explains the statutory sentence, which was intended to clarify the principle of non-liability when the default is due to grounds not attributable to the obligor. But when you look at the language, it may not be sufficiently clear, even under the new law. So it says, in light of the contract or other sources of obligation and the common sense in the transaction, which is a little bit awkward translation. But even if you look at the Japanese original, it is still not 100% clear. So this is another problem. And I would like to very briefly talk about the different approaches taken in the ASEAN countries. Next page, please. So it's very important to understand that different approaches may be taken in different jurisdictions in Southeast Asia. And like Singapore, Malaysia, there are special laws relating to the remedies provided in regards to COVID-19 situation. So the starting point is to look into the specific laws. And in some jurisdictions, they have legal definition in their applicable law of the force majeure defense, like Indonesia. So the starting point is that law defining the force majeure event. And I understand that in some jurisdictions, particularly common law jurisdictions, the approach taken in interpreting the force majeure clause may be stricter than what you may expect under Japanese law. And I understand that in Malaysia and some other common law countries, even if there is no force majeure clause applicable to the case, under the circumstances, you could have further defense of frustration, but I understand that is not an easy path. And finally, I would like to briefly touch upon the possibility of the claim for additional cost, which is often a big issue in the construction disputes. And interestingly, there is a FIDIC COVID-19 guidelines, which talk about the interpretation of relevant FIDIC contractual terms. And if you look at the scenario 4, then it says that maybe use of force majeure clause for the claim for additional costs may be difficult, but if you can resort to the change in legislation clause, you may have a better chance. But I will stop. I'm gonna stop here. Thank you.
Thank you, Hiroyuki. That was a really great overview of the types of legal remedies available in Japan and the civil code. I think it was also useful that you touched on some of the other jurisdictions, particularly in ASEAN. And along those lines, I think it's a good time to look now at Vietnam specifically, Vietnam being an increasingly important jurisdiction for Japanese trade and investment. It's also been very remarkable for its COVID-19 response. So if I could turn to Min to talk a little bit more about Vietnam and the impact of COVID-19 there.
Thank you, Michelle. Michelle asked me to talk briefly and quickly about the Vietnam success story. So I'll be talking mostly about what did not happen. As of December 11th, The Ministry of Health confirmed that Vietnam had a total of 1,385 cases. Of this number, 1,225 have recovered or been discharged. The recorded fatalities are 35. So the IMF has given Vietnam credit for taking decisive steps to contain the health and economic fallout of COVID-19. A couple of recent community infection cases illustrate the decisive action that Vietnamese authorities have taken. Recently, there were 4 community cases in Ho Chi Minh City traced to a airline steward. Vietnam temporarily suspended all inbound international commercial flights from December 1st, except for repatriation flights of Vietnamese citizens. More than 3,200 people have been tested and found to be negative. Businesses have been asked to close because the patients visited the businesses. In July, a community transmission case was found in Da Nang, which prompted a second lockdown of Da Nang, which is one of the major cities in Vietnam and one of the major tourist destinations. So that's kind of how Vietnam has gotten through the pandemic with the low numbers that it has. Having said that, the pandemic has had a definite economic impact, as it has everywhere else. Vietnam Airlines, the national carrier, has run up 1.3 billion, estimates that it will have 1.3 billion in damages from closing its routes. Revenues for the first 9 months were 58% down. I guess the reason for that is because Vietnam Airlines is fortunate enough to be able to maintain the domestic air traffic. And so that allowed them to continue to collect revenues. But business travel is coming back very slowly. There's an agreement with Japan that was entered into on November 1st, but that remains to be implemented. We hope to see protocols and procedures by early this year. Same thing with Korea. Let me talk now about an example affecting Japanese business. As some of you may know, the Saigon Metro project is funded entirely with Japanese ODA. And so the problem that came up was that 100 foreign engineers could not enter Vietnam in order to work on the project. Of those, and they all were working for Hitachi, which had one of the main contracting packages involving tracks, maintenance equipment, and trains for the first metro line, 20 kilometers, 14 stations. They had 82 engineers who were supposed to come in March, and they were not able to come in, got stuck outside Vietnam. They had 18 engineers who were supposed to come from Tokyo with the first train, and they were also stuck, could not come in. And that, of course, had a ripple effect and caused delay for the project. So what occurred was that meetings took place between the Saigon Metro management authorities, the contractors, the government, and that eventually resulted in Vietnam lifting the mandatory 14-day quarantine requirements for foreign experts, provided they were tested before, tested after, monitored closely while they were in the country for the first 14 days. And at that point, either they left before the 14-day ended, or if they had tested negative throughout, they could stay. Now, other sectors were also very profoundly impacted. The capital markets, IPO deals disappeared, real estate inflows of capitals collapsed. But I think the good news from a legal standpoint in terms of today's program is that we have not seen a wave of litigation based upon claims related to the pandemic. In fact, in the Saigon Metro project that I just talked about, because it was an ODA project, they had to use a FIDIC form contract. And that contract had a clause providing for an extension of time in case of unforeseeable shortages in the availability of personnel or goods caused by epidemic or governmental actions. In addition, there's also a specific clause covering delays caused by authorities. So there was plenty of grounds within the contract to discuss extensions of time. In addition, there is a general force majeure defense available under the Civil Code, which is if an event of force majeure is defined under Article 156 of the Civil Code as an event which occurs in an objective manner, which is unforeseeable and cannot be remedied by all necessary and possible measures. Somebody who successfully makes such a claim is then absolved from liability, pretty much the way it works under the Japanese Civil Code. But I should also mention, and that the most recent revision of the Vietnamese Civil Code added for the first time ever a fundamental change of circumstances provision. And that provision is fairly well structured. It requires, first of all, that a fundamental change must have occurred. And in order to find that the fundamental change has occurred, 5 conditions have to be met, all 5 of them. 1, there is a change of circumstances due to objective reasons occurring after the contract is entered into. 2, at the time the contract is entered into, the parties are unable to foresee the change of circumstances. 3, the change of circumstances is so significant that the contract would not have been entered into or would have been entered into with completely different provisions if the parties had foreseen the change. 4, the continuation of performance of the contract without changing the contents of the contract will cause serious damage to one party. And 5, the party whose interests are affected has taken all necessary measures to the best of its ability and consistent with the nature of the contract, but is unable to prevent or mitigate damages. Now, this is a new untested provision. However, we can already see that there's a fundamental distinction between the force majeure clause and this kind of a claim, because under this kind of a claim, you are saying that the contract is enforceable, but you're saying that performance of the contract will cause major damage. And so that then leads to an invitation to renegotiate. And with the big difference that if the parties do not agree, then either party can resort to the courts and ask for judicial intervention to terminate or rewrite the contract. Now, depending on the situation, depending on the leverage that the parties have, a provision like this, could play into the advantage of either parties in terms of renegotiation. But so far, there's one case, a fairly complex case that we're involved with, but we haven't seen in general this kind of claim being made. But as Peter says, in some of these cases, we won't see a dispute until much further down the line. But of course, if you're talking about a big project like Saigon Metro, by the time it's finished, there will be many other claims that don't relate to the pandemic at all, if there are disputes. So bottom line is, Vietnam has minimized the economic damage from COVID-19. It's the only country in Southeast Asia on track for growth this year. The economy is expected to grow 2.4%. The IMF is predicting a strong economic recovery in 2021, with growth projected to strengthen to 6.5%. And what we're beginning to see is the benefits of the major realignment of supply chains between the US and China, and between also Japan and China and Taiwan and China. At least 15 Japanese firms, according to the Vietnamese press, based upon a JETRO list, have registered to benefit from a Japanese government program to move production to Vietnam to diversify the supply chain away from China. So bottom line is, I think no major damage to report from Vietnam in terms of the pandemic, and the economic prospects look bright. Thank you.
Thanks a lot, Min. That's really interesting, and I think that the Saigon Metro project is exactly the type of issues that Peter spoke about when we opened up the session. So thanks a lot for that case study and overview of how things are going in Vietnam. If we could look at now Singapore, Singapore being another really important jurisdiction for Japanese trade and investment. And specifically the legislation that was enacted in response to COVID-19, if I could ask Lung San to speak a little bit about that.
Sure, Michelle. Well, Singapore, as Min says, is not spared. I don't think any country is spared from the economic fallout. And sadly, one of Singapore's most beloved departmental stores, Robinson, is closing down. And I think not just Singaporeans, but many visitors to Singapore have fond memories of Robinson, but it's going now, a casualty of COVID-19. But as anybody can guess, this lockdown and the pandemic have actually caused a lot of problems for construction, well, amongst all other industries. Basically, there will be delays and increased cost. Singapore has introduced a range of temporary measures to give temporary reliefs to all kinds of sectors. The construction is also not overlooked. There have been, for example, temporary measures for the construction industry to deal with delays and increased costs. And completion is extended by law by 122 days to address delays between April 2020 and August 2020. So that's to give breathing room to the construction industry. The latest measure is called the Realignment Framework or Realign Framework, not for the construction industry, but for small businesses. And this will take effect for 6 weeks from January to the end of February 2021. What it does is that it will allow certain businesses to renegotiate certain types of contracts with their counterparties. And these types of contracts are contracts like leases of non-residential property, hire purchase, sale and purchase of goods and services. Basically, it is to help small businesses, and the businesses which qualify for such reliefs are those which do not have annual revenue beyond 30 million Singapore dollars and have actually experienced a fall of at least 70% in monthly average gross income for July to December 2020 compared to previous years. What it does is to allow these businesses to renegotiate their contracts, and if negotiations fail, then the contracts will be terminated on just and fair terms. What are just and fair terms? Can go to an assessor, an independent assessor appointed by Ministry of Law. So these are just examples of ongoing temporary measures introduced by the Singapore government. Thank you.
Thanks, Lun San. Appreciate that overview. I think it's very interesting to see what the legislative responses have been from different countries. Staying now in Singapore, if we could also then turn to the legal remedies under Singapore law, and also under other common law jurisdictions as well, and see how those compare to what's offered under Japanese law and Vietnam law. Yet, Min, could I turn to you to speak about Singapore law?
Sure.
Thanks.
I think participants would have heard all the main terms that would be said many times during this presentation and since the pandemic started. So the contractual remedies as well as remedies under general law So under contractual remedies in Singapore and in most of the common law jurisdictions, they constitute the force majeure clauses. And I think what we have also heard Min mention, material adverse change kind of clauses. Under general law, you have the doctrine of frustration, which I think is applied in quite a number of jurisdictions as well. The legal position in Singapore is like most common law jurisdictions, including Malaysia and the UK, and is generally the same or very similar. And some jurisdictions may also have some of these doctrines codified. So for example, in Malaysia, the doctrine of frustration is actually codified. Coming to force majeure clauses first, which I think many people are concerned about. And basically, force majeure is defined as an event that is beyond the control of a party that prevents it from performing its obligations under a contract. And the common examples that you always hear in force majeure clauses are acts of God, civil disorder, war, military operations, national emergency, acts or missions of government, etc. Whether you can rely on force majeure clauses actually depends on whether you actually have such a clause in your contract to begin with. And the clause must also provide that the event that has occurred is a force majeure event. The clause will usually provide for either the modification or termination of obligations if a force majeure event occurs. So for example, the clause could grant entitlements to additional time, extra time for performance, or additional payment for performance, or provide for a temporary suspension of contractual obligations. So these are all possibilities. And in some cases, the wording of the force majeure clause may even have the effect of excluding the possibility of terminating obligations. So it actually says that you can't terminate your obligations even in the event of a force majeure. There have been a few reported cases. There have not been cases in most of the jurisdictions, but I found a few cases in India, for example, dealing with COVID-19 related events. And the general trend in those cases seemed to be either that the court found that the force majeure clause was inapplicable in that particular situation, or that COVID-19, while no doubt being a force majeure event, but in those particular cases, the non-performance of the contractual obligations actually took place before the pandemic. So the parties have actually started to default before the pandemic, and therefore COVID-19 was not the reason for non-performance and could not be relied upon by the parties. Now, of course, that's quite specific to those cases that have gone before the courts. But I think in most jurisdictions, we haven't really seen reported cases that are COVID-19, specifically COVID-19 related. So your force majeure clauses may also specify that an epidemic or a pandemic is a force majeure event. And if that's the case, then it will be easier for a party to be able to use that force majeure clause. But even if it does not expressly state so, contracts would frequently state that an act of God is a force majeure event, and the COVID-19 pandemic could possibly constitute such an act of God. They also often, force majeure clauses also often provide for events involving acts of government, for example. And this may arguably extend to any city lockdowns, travel bans that we have seen being implemented in many jurisdictions and by the authorities in response to the pandemic. So a party that's seeking to rely on such a clause must also show that it has taken all reasonable steps to avoid its operation or to mitigate the negative results. Some of the measures that some of the countries we have seen have been doing to help companies invoke the force majeure clauses. We see that in the PRC, for example, they have been giving out force majeure certificates to help companies avoid penalties for breaching contractual obligations in light of the COVID outbreak. And even though the legal status of such certificates remain to be seen, but it is quite useful to support companies in such a situation. They at least have something they can use to try and argue force majeure in their case. And in India, there are also several governmental departments that have issued such similar certificates or memorandums to help companies. Coming to the issue of frustration. frustration is used as a general remedy under general law, and is not contract-based. So if an unforeseeable event beyond the control of the parties makes the performance of the contract either impossible for a party or radically or fundamentally different from what the parties had intended when they entered into the contract, then the parties may rely on the doctrine of frustration to say that the contract has come to an end. The key difference between frustration and force majeure, and I think Mr. Hiroyuki has mentioned that earlier, that there may be some confusion about this. And the key difference is that the contract, that force majeure is actually a contractual remedy, and but frustration operates under general law. So you can use it even if your contract doesn't have such a force majeure clause. And in addition, frustration also operates to discharge the contract in its entirety, unlike in force majeure clauses, which often provide for temporary relief and with the option of termination in the event of a prolonged force majeure. Those are the kind of usual force majeure clauses that we see in operation. To establish frustration, there are usually two categories that we hear about, and one is supervening illegality, and the second is the impossibility of performance. So on illegality, you can imagine that in a pandemic situation, if you have a quarantine order that disallows you from going out to perform your contractual obligations, you may be discharged from performance of such obligations. But of course, the effect of any such supervening illegality will depend on the nature of the contract. So for example, if the illegality only applies for a part of the contract or part of the duration of the contract, and it's not for the entire contract, then you may have difficulties establishing illegality. So the seriousness of the delay, the duration of the delay would be applicable. Under impossibility of performance, you can imagine that if you are detained somewhere or in a lockdown, and you cannot, for example, if a performer or an artist has to be somewhere to perform a contractual obligation, but he or she is unable to get to that place to perform the obligation on a specific date or time and a place. So then in that situation, there is impossibility of performance, and you could use frustration as a way to save you from having to be in breach of contract. So that's what you usually see in the cases of frustration. Temporary impossibility of or inability to perform a contract, as I mentioned, may not lead to the discharge of a contract if the contract can still be effectively performed later on. And coming to an issue that I understand is of relevance to many companies, mere inconvenience, hardship, financial loss, increased costs usually are not sufficient to discharge a contract. The position in Singapore law, at least, is that a mere increase in cost or price is generally insufficient on its own to constitute what we call a hindrance or a prevention to performance. But in one of the leading cases in Singapore, it was held that that while mere increase in costs is not going to be sufficient, the court left open the issue as to what the legal position would be if the increase in cost is what they call astronomical. So the example given was an increase of 100 times of the cost. And in other words, so a mere increase in cost per se will not result in a frustrating event, although it might if the increase is extreme. But from what we have seen so far in the Singapore cases and the English cases, an increase of 15% all the way up to 100% were held by the courts to be insufficient to establish frustration. So I think it remains to be seen what kind of extreme or astronomical increase in cost would actually lead the court to interpret that as deserving of a frustration to be applied. But I do think that the world has not seen a pandemic the one that we are seeing now, which affects everybody globally. So it could be, and I think it's possible, that the courts may adopt a slightly more lenient attitude towards increased costs in appropriate situations. I'm going to deal very, very briefly with the material adverse change clauses, and that's mainly because very few cases have talked about material adverse change clauses, what we call MAC clauses. And these are typically found in M&A or financing agreements. And in the context of M&A agreements, if you enter into a merger and acquisition kind of agreement, such clauses aim to allow purchasers to withdraw from a transaction or give a basis for renegotiation of terms if the target company suffers a material adverse change between the signing and the closing of the transaction. And these clauses often appear either as a condition precedent or as a warranty, and the party relying on the clause would have to show that at a certain material adverse change event has actually occurred. But it is quite risky to invoke such a clause because the party would have to take the risk of incurring liability to the counterparty for repudiatory breach if you invoke such a clause when it is actually not entitled to do so. As I mentioned, very few cases have dealt with the interpretation of such clauses, but the English case law sets out various principles on the interpretation of such a clause, and they include a change is only material if it significantly affects the company's ability to perform its obligations under the agreement. It is not material if it is merely temporary, and the party invoking the clause cannot do so on the basis of circumstances of which it was aware of at the time of the agreement. But you could invoke the clause where conditions worsen in a way that makes them materially different in nature. So whether the COVID-19 pandemic would constitute a material adverse change will depend on the precise phrasing of the clause to be relied on, and also the specific circumstances impacting the parties to the contract. I think that's all I have on the clauses and the general remedy under common law, and let's hear from other speakers.
Thank you so much, Yumin. That was a really comprehensive look at the important clauses under Singapore law, and I do appreciate that. If we've talked with a lot about legal doctrines, legal terminology, and so maybe we can sort of think about how all of this would actually work in practice by looking at a hypothetical or an example of a dispute that might arise in light of COVID. So what, if I could ask Peter to help us out with this, what remedies might be available to a Japanese contractor, for example, to a Japanese a Japanese project owner when a contractor or a supplier in another country, let's say Thailand or some other country, disappears or goes insolvent due to COVID-19? What kind of remedies might be available to the Japanese party or project owner there?
Thanks, Michelle. I'll just focus on the circumstance where the Japanese company is the main contractor, so it's working for the employer, whether it's a government or a private employer, and it's got some issues with its local subcontractor. I won't talk about Thailand specifically because I'm not a Thai lawyer. We'll just talk in general terms. So if the contractor disappears or goes insolvent, that's a problematic circumstance. The first thing to do, of course, is to look at the contract and then to look at what remedies might be available under mandatory law. In this case, it would be Thai law. One thing that Japanese companies sometimes forget to do is, prior to the contract, think about what steps you can put in place to make it easier for you if the contractor disappears. Now, one is due diligence on the contractor. If you've never done business with this company before, do some checks on them. Are they reliable? Have they got a reputation as being a corrupt company, taking bribes? You probably don't want to be in business with a company like that. And then make sure the contract is well prepared. Does it provide you, as the main contractor, with clear rights of termination? Or do you have to rely on the local mandatory provisions of law in order to terminate? Generally, you're better off having clear contractual rights of termination that you can rely on and point to in the contract if there's a problem with the local contractor. The other question is, what type of notice provisions are in the contract? If you're having a problem with a local contractor, before they disappear, there's a chance you'll already have a dispute with them, whether it's about their performance or whether it's about claims for additional cost. Look at the contract and see whether it allows you to provide written notices in order to position yourself to the best advantage if the dispute is not resolved and you're in a position whereby you need to terminate them or make a formal claim for costs later on. Now, some Japanese companies, as other companies around the world have, is a concern about being too formalistic with your business partners and sending them contractual notices. Now, when you're dealing with companies in difficult jurisdictions, I wouldn't say Thailand, for example, Indonesia, you're much better off sticking to the contract, sending the contractual notices to create a paper trail of evidence that you can rely on if the company decides to disappear or otherwise behave badly. Now, Japanese companies, understandably, are sometimes hesitant to write formal letters to their business partners, but this can be done in a sensitive way. You send the notice and then ring up the counterparty, have a meeting, explain that you're just doing this as a formality. You're not doing it as an aggressive tactic, and that can make it a lot more smooth process. Another thing which I think Uwet mentioned was performance bonds. If there's concerns about the solvency or the ability of the counterparty to perform, potentially a performance bond for larger value contracts may be useful. Now, let's assume that the counterparty has disappeared from the project. You've got them on one package in the infrastructure project or construction project, whatever it is, and they've decided to abandon the site and leave. Now, what remedies you might want to utilise will depend upon why they've left and the circumstances. Did they leave because you're having a dispute about costs? Did they leave because they got a better deal down the road, earning twice the fees? Your approach will depend on the facts. But if they have abandoned the work and walked off site, at least under English law, that would be deemed a repudiatory breach of contract because they have basically torn the contract up and thrown it away, and you would be able to terminate. But again, you should look at what the contract says about termination. It may be that your damages entitlements might be different depending upon whether you terminate under general law or you terminate under express termination rights set out in the contract. So you need to look at that. The other thing is, in terms of remedies, whilst you're dealing with the counterparty, you must remember, as Uwet was saying, that you need to reduce the negative impacts by taking mitigation steps. And that will probably initially involve getting a replacement contractor in, which is not easy, but it would need to be done. The other thing is, sometimes I've noticed Japanese main contractors are very hesitant in communicating bad news up to the employer. If there's problems with the subcontractor, sometimes Japanese main contractors try to contain those problems at the lower level and may not communicate them on a timely fashion up to the main contractor. This happens in other countries as well. That should be avoided because there's nothing an employer dislikes more than being kept in the dark. So just look at who needs to know what's going on and try and get the employer to buy into the efforts to resolve the matter, because they probably want to be involved in a solution rather than being not aware of the problem at the very outset. Now, in terms of these efforts to mitigate, everything should be put in writing. As I was saying, contractual notices create evidence that you, the Japanese company, have been doing everything properly and to the best of your ability to move the project forward and to minimise the delays or other damages to the project. And in terms of insolvency, very briefly, if the other parties become insolvent, what remedies would be available? Generally, it's a matter of the local law because it's a regulatory issue by and large, but there's some preventative steps you can take at the outset, and that's to ensure that in your contract you have an express right to terminate or take other steps if the counterparty becomes insolvent. So just ensure you have those provisions in your contract. Thanks, Michelle.
Many thanks, Peter. I think that was going to be, that's very helpful for people who find themselves in sticky situations in light of COVID-19. I'm conscious that we are running short on time, and I know that there's a lot that we could cover today. So we're going to just skip on over to the next topic, which is, looking at new creative avenues for recovery, and whether looking at investor-state arbitration might be an alternate avenue for recourse when commercial, going the commercial route isn't going to be quite feasible. And if I could ask Hiroyuki to give us a few very brief comments on when this is something parties might consider and how it would work.
Yeah, let me be very brief. I can say that it just gets started. The discussion started, and the investor state arbitration specialists talked about the possibility of raising claim and fair and equitable treatment and indirect expropriation, etc., etc. And this is not an easy path, and the arbitration may be costly and time-consuming. But we know that there are some threatened claims against Peru and Mexico. So this is the area where you may see developments, and the important point for Japanese companies is that you shouldn't forget about this possibility. So just consider and analyze. Thank you.
Great, thanks a lot. Lung-san, any additional brief comments there?
Yes, it's an interesting idea, because in the midst of COVID-19 and all the extraordinary measures taken by a government to deal with it, you may have certain, for example, acquisitions or requisitions of services, let's say in the private healthcare sector or other essential services, which the government needs to requisition or divert in order to cope with the emergency. And the question is whether that amounts to an expropriation of a foreign investor's investment. Now, of course, most free trade agreements or treaties will allow a state to preserve public order or act to protect public health. So that might be an exception. And even if there is expropriation, if it is done in a non-discriminatory manner for a public purpose, and as long as fair compensation is given, that might be justified. So certainly, I think people talk about potential for investor-state claims arising from COVID-19, but I don't think there have really been many or even any that I know of that has been brought because the state has taken such emergency measures.
If I could jump in to say something very quick, as somebody who has been involved primarily on the defense side. Usually these claims are brought by investors who are on their way to leave the country. So I think for Japanese companies, their activities usually come within the framework of very strong government support and a government relationship between the Japanese government and the Vietnamese government. So I would think that there are remedies and tools available to solve whatever the claim is that the Japanese company would have that can effectively remedy the problem before you get to an investor state claim.
Thanks very much. Three very interesting and useful perspectives there. And I do wish we had the time to dive in more on this interesting concept of using investor state in response to COVID, but we'll have to save that for a future webcast. If we could now, switch gears a little bit and just talk about what the future might hold in terms of trade and investment in the region. And we can look specifically at the Regional Comprehensive Economic Partnership, or the RCEP, that was recently signed. and the impact that that's going to have on trade and investment. If I could ask Lung Sen to speak a few minutes about that.
Sure. I think, as you say, Michelle, it's good to switch gear from all the depressing news about COVID-19 to something a little more upbeat and perhaps more promising. As you say, the regional comprehensive, the economic partnership agreement is something that had just come into effect. Well, it hasn't come into effect. It was actually signed on 15 November 2020. And it seeks to reduce tariffs on a variety of agricultural and manufacturing services, including setting new rules on e-commerce, investment, and intellectual property rights. Now, 10 members of ASEAN and 5 Asian countries, including Japan, South Korea, China, Australia, and New Zealand, have signed the RCEP. Japan is already aware of regional free trade agreements because Japan led the prior free trade agreement, and that is the CPTPP after the USA dropped out. So the Comprehensive and Progressive Agreement for Trans-Pacific Partnership, led by Japan, was signed in last 2018 and came into effect on 30th December 2018. That didn't include all members of ASEAN. It included 10 other countries, altogether 11 countries. And it happened after, of course, USA under President Trump pulled out of the TPP. Now, the RCEP is new, and it is the first multilateral free trade agreement that China has signed on to. The RCEP included all the ASEAN countries. Okay, India has pulled out of the RCEP. Initially, was supposed to be in it. What's the difference between CPTPP and RCEP? Well, the differences are in some of the key features, such as tariff elimination, labor, and environmental standards. The CPTPP is more aggressive in aiming for greater elimination of tariffs, up to 99% in some cases, and higher level labor and environmental standards. It also seeks to place some restrictions on state-owned enterprises. Now, that is why some ASEAN countries with smaller economies have not signed up to the CPTPP. They were not comfortable with this level of commitment, but they have signed up to RCEP, which is more inclusive, and that reflects their desire to attain a more acceptable level of commitment. According to Japan Times, the agricultural lobby of Japan has actually succeeded in getting significant concessions for Japan in the RCEP. In particular, under the RCEP, Japan can maintain tariffs on 5 imported agricultural products. That would be rice, wheat, beef, and pork, dairy products, and sugar crops. On the other hand, Japanese exports will benefit from the gradual elimination of tariffs on sake and soju. Okay. The RCEP requires that China and South Korea gradually eliminate tariffs on sake and soju. Contrary to popular conceptions, although the RCEP featured China, it was not China-led. ASEAN played a central role in driving the negotiations. It is true, however, that the RCEP is a significant impetus for greater economic integration or cooperation in North Asia, in particular between the 3 Asian powerhouses of Japan, South Korea, and China. Both Japan and China have already expressed a view that they desire to speed up negotiations on the trilateral China, South Korea, and Japan Free Trade Agreement once the RCEP is in place. Therefore, the RCEP is the most significant impetus for trade and economic cooperation for ASEAN and Japan since ASEAN Plus 3 was formed as an informal forum for cooperation between ASEAN, Japan, China, and South Korea in 1997. According to computer simulations by the Peterson Institute for International Economics, the RCEP could add $209 billion annually to world incomes. and $500 billion to world trade by 2030. So I think that would be a high note, probably to end the last topic on this webinar. Thank you.
Absolutely. That's certainly a positive note to end the webinar on. Without, hopefully getting back to any negative news, I wanted to give everybody one last opportunity if they have any final concluding thoughts to offer on the COVID situations in ASEAN or Japan, and what it might mean looking forward.
Well, I can only say that I look forward to really traveling again next year.
Absolutely.
And hopefully be in Japan.
Absolutely. I think those of us who travel to Tokyo often are missing Tokyo very much.
Yes, I do hope that we can get together in person in the near future. Thank you.
Well, thank you everyone for joining us today. And thank you to our wonderful speakers for covering a lot of ground, I think giving a lot of really great practical advice to our viewers. I do hope that you join us for other SIAC events as well as other ASEAN Japan Center projects as well. Thanks very much and have a great day.